Friends, what should you do if your I-485, the adjustment of status application, gets denied? Why? Because you forgot to include the affidavit of support. Guys, this happens so frequently. We're going to talk about that issue in this video. But before we do so, as usual, I send my thanks to you for watching this video, for sharing, for commenting. Guys, if you have not yet subscribed to McBean Immigration TV, go ahead and do so right now. Hit that notification bell and make sure that you stay in touch with me also on Facebook and on Instagram at McBean Immigration Law. And certainly give my office a call so that we can get to know each other and talk about your immigration issue. Now let's get into it. Here's the story. I've been seeing so many cases like this recently. People go out on their own, file the adjustment of status application, thinking I could handle this because why not? I'm smart, right? I could fill out an application and I could attach some evidence to it and I know how to mail it off. No brainer, right? But yeah, you do all of that and then guess what happens? The government denies you because you did not include what they consider to be a required document in the beginning when you submitted your application. Because guys, I have an old video, I'm going to link to it here, that talked about the fact that the USCIS has a new policy in place which says if you don't read our instructions carefully and submit those initial required evidence that we ask of you, we could just deny it outright, deny, without giving you an opportunity to cure it. I've seen cases in which they're still giving some people an opportunity to cure the problem, but in other cases they're saying no, denied. And so that's what can happen with the adjustment of status application if you do not submit a required initial evidence. And I'm also going to show you shortly on this screen the initial required evidence that's just laid out on USCIS's website in a nice format so that you can just do like a little checklist and make sure that you've included those initial evidence with your filing. One of those documents, friends, is the I-864, which is the Affidavit of Support. That must be included with the application filing. Now, what happens now if you've been denied because you didn't know about this? And the letter that you've received says, if you think we've made an error in this decision, file a motion to reopen or reconsider. You have 30 days or 33 days by which to do so. And that's it. That's what they're telling you. And then obviously in this denial letter, there's more language that's in there, right? That says that if you don't have a lawful status, we now know that you do not have a lawful status here and you have X number of days to leave the United States, or else we may issue a notice for you to appear in immigration court so that we may begin proceedings against you. So it includes language like that in addition to if you have a work permit, you're going to have to return it and blah, blah, blah. Right? So all of that is in there and people get this letter and they are afraid. They're like, oh my God, what am I going to do? Maybe I should just file a motion to reopen my case and reconsider it. So let's talk about the pros and cons of doing that, because it really is not that simple. If you decide, I'm just going to file a motion to reopen or reconsider the decision, and I'm going to include my affidavit of support now because I forgot it last time, so I'm just going to include it this time. That's one approach, and I know, and I have colleagues who've reported that that's how they used to handle it. When people come in and they had been denied because they forgot to include the affidavit of support, they would say, hey, let's just, file the motion and we'll do the affidavit and we'll include all of the evidence again and we'll send it off. And in those cases, the government did in fact reopen the case. But what's happening now, there's a big unknown, and it's because of public charge. I don't know what they're going to do if we just say, okay, we're going to turn around, we're going to reopen, we're going to file this motion, and we're going to include the I-864. Are they going to accept it? I don't really know based on my experience yet, because public charge is now in effect. And public charge went into effect on February 24th, 2020. And the government is taking public charge seriously, and they now want new evidence and a new form, the Declaration of Self-Sufficiency and this and that. The process has gotten a whole lot more complex, and we know the reason for that, right? Under the Trump administration, they want to deny more people of the green card. So it's gotten complex under public charge. So the big unknown is, how will the government treat a motion to reopen now that public charge is in effect? Is it going to be accepted? Is it going to be reopened? Some people may have success with it. I've not seen that yet. It's still kind of early, waiting to see. It's only been a couple of months since public charge is in effect. And so I always tell people, you know, are you willing to roll the dice and do this motion versus refiling and doing it the right way? You want to roll the dice knowing that in several months you'll get this decision, or sooner you'll get this decision, and it could very well be another denial, and therefore you've lost time, right, and money, because there is a filing fee in the 600 range for that motion, right? So you can lose the filing fee and time, which you can never get back. So do you want to roll the dice? There's a big chance that they may deny it. They may reopen it. I don't know. It's too soon to tell. Public charge has only been in effect for a couple of months. Don't know. So I give them that option. But if you decided to refile the I-485 with the affidavit of support, just keep in mind that you'll now need to go under public charge unless you're seeking a humanitarian pathway to a green card, right? Such as you're an asylee or you're a victim of domestic violence or some other special immigrant. They do not have to go through the public charge process. So in summary, friends, firstly, do not panic when you get that denial letter based on the fact that you forgot to include the affidavit of support, or actually maybe you didn't even fill it out correctly, because that happens a lot too. Don't panic. If you decide to file the motion, just consider the fact that they may reopen it, yeah, or they may not, because public charge is in effect and they want more information from people before they make a decision about the adjustment of status. So keep those things in mind, and I hope you found this video helpful. I'm speaking with you as if I would speak with anyone who, who I have a consultation with. So I hope you found this helpful. Be sure to share it with other people. Drop me a comment below. And guys, I'll see you in the next one. Thanks for watching. Bye-bye.